This is Luke Sheehan for the Village podcast in episode 4 of a series on law and literature with barrister David Langwallner. This episode, David means to talk about advocates and judges, judgments and the arguments and performances of advocates as great examples of really literature from the past, leading on from the end of the last episode when we discussed in brief the trial of Oscar Wilde and the advocate Edward Carson. David, speak about Edward Carson.
Well, I mean, you get hung in certain parts of Ireland for saying positive things about him, because of course he's the inspiration behind Ulster Unionism.
Right.
But that does not detract from the fact that he was probably the greatest English advocate of the 20th century. The Wilde case, which we went through at length, obviously, and you were quite correct about this, it has disturbing undercurrents. You were pointing out that Wilde was far from squeaky clean in many ways, and that's right. And we went through the fact that he was playing with Carson. We also went through Carson's detestation of him as a human being because of his well about homosexuality. And of course, Wilde should never have taken the libel case.
Mm-hmm.
But that case is only one of Carson's great cases. Put him in a favourable light. He was also instrumental in a case called the Sneed case. It's popularly known as the Winslow Boy, and I think almost everybody's heard of it, where this cadet was accused of theft and he was completely exonerated. It's a bit like the Dreyfus thing we mentioned. And Carson, in fairness, took up the cudgels on him. And he went to significant extents to get the case dropped, even touching up, you might say, his friend and adversary, Sir Rufus Isaacs, who was Lord Chancellor at that point in time. And we'll come back to Isaacs later, certainly. But, that portrays Carson in a much better light. And then, of course, he was in the Cadbury libel trial, where the Cadbury Company was accused of profiting from slavery. The jury awarded them 1 farthing damage because of the substandard work conditions that they were sourcing their coffee from in the Caribbean. So there was a whole array of great performances and great comments by him as an advocate. He famously was doing a case in a tribunal, and the judge says to him, "Sir Edward, I'm not, this is a tribunal. I'm not acting as a judge." Carson responded, "Any bloody fool can see you're not a judge," and walked out. Extraordinary stuff. And he had balls of steel, and he put up with Wilde's impertinence day in, day out, and brought Wilde to his knees and crippled him. So there's no question about his stature as an advocate, but it was an age of golden advocates who used the art of cross-examination and the closing speech as art forms. These were highly literate people and highly skillful both in the technical use of language and also in the dying art of oratory and wit and so forth. We mentioned Rufus Isaacs, who really effectively stopped the case going ahead through Carson's intervention. At this stage, Rufus Isaacs was Lord Chancellor, and he had a glittering career. But he was also a barrister. He was a prosecutor, mostly. And the 2 other great advocates of that era with Carson were the legendary Sir Edward Marshall Hall, whose closing speeches were theatre and vaudeville. I mean, he was representing an Austrian prostitute in one case, and his closing speech at the very end, turns around to the jury, hands akimbo, and he goes, "Ladies and gentlemen of the jury, God didn't give her a chance. Why don't you?" And he was a vaudeville act. Got some incredible results, but he's up against, in the Seddon murder case, Seddon was accused of poisoning somebody for an inheritance. It's a very unfortunate thing. We discussed, I think, briefly the Bodkin Adams and Shipman cases in the last podcast. And, Seddon was another type of bounty hunter. He's defended by Sir Edward Marshall Hall.
Mm-hmm. Mm-hmm.
Hall says he shouldn't give evidence, but Seddon decides to give evidence in a murder case. Some would say you don't have a choice. But the case was not incredibly strong until Sir Rufus Isaacs destroyed him with what is one of the most dangerous armories in the barrister's art form. And it's the surprise question or the trap question.
Hmm.
Now, the question of the inheritance that Seddon was seeking from the person he poisoned, or the assets, was also, it was in evidence that he had given to the deceased merely a pauper's funeral,
Uh-huh.
the most basic funeral imagined. Now,
Yeah.
here's what Sir Rufus Isaacs did then. He's cross-examining Seddon, and he says this. It's a really simple question. And
Yeah.
Seddon pretends that he's completely perplexed by it. Did you?
Yeah.
Well, it starts like this. He says, uh, um, Miss Barrow lived with you from July 26, 1910 to September 14, 1911. Seddon
Yeah.
says, yes. Isaac says, this is the question. Did you like her?
Mm.
Now, you see, he had given her a pauper's funeral. So
Mm.
if he'd said he'd liked her,
Mm.
Isaac's next question, well, if you liked her so much, why did you only give her a pauper's funeral?
Mm.
If he said he didn't like her, then it's
Mm.
motivation for poison. And
Mm.
in the transcript of the case, you can see he's squirming. What do you mean? Did I like her? Says. Isaac says, yes, that is the question. Said said then says she was not a woman you could be in love with, but I deeply sympathized with. Don't let me worry you any further. God, that convicted said. Now, in a way, it's deeply unfair because there was no way out of that question. Do you get that? I mean, either way, he was damned if he did, damned if he didn't, because of the pauper's grave thing. He would, and if he said he didn't like her, well, then he's why did you live with her, and is that a motivation for poisoning her, and so on. The judge in the case was deeply unsettled um, when the verdict was announced, but particularly when he had to sentence Seddon to death, and Seddon did hang. And the surprise question can be deeply unfair. There's another famous English barrister called Norman Burkett, and he's asked, it's an expert in a murder case. And the question is deeply unfair, but destroyed the expert because a lot of the evidence was, could it have been an accidental fire? And this
Mm-hmm.
is a guy who's an expert in all this stuff. And Burkett gets up and he says, do you know the coefficient of brass? And the expert says, Not offhand. No, it's actually a very tricky technical question for an engineer expert to answer." And he hesitates and he hums and he haws, and Burkett boxes him into a corner. And you're an expert whether it was an
Mm-hmm.
accidental death. And so the surprise question can be absolutely deadly unless there's an answer to it, which is irrefutable. Those are both examples of deadly cross examinations. Now, we've mentioned, and I think you said to me that I've been pronouncing it wrongly, uh, hitherto, the Scopes trial. Have I got the pronunciation correct this time?
I believe so.
Yeah. And that's, of course, the monkey trial. And we've
Right.
mentioned it several times. But I don't think we've ever gone through the context of Darrow, the great liberal progressive trial lawyer, the attorney for the damned, the
Mm.
greatest trial lawyer who's ever lived, and his cross examination of William Jennings Bryant. Now, the context, of course, was Bryant was prosecuting the case, and the judge had refused Carson's multiple applications, multiple, to have experts in Darwin, because the trial was about prosecuting him for saying that man descended from the apes. And so Darwinism is as tricky a question in America today again. So the trial has peculiarly resonances. But the judge disallowed every single attempt by Darrow to call an expert on Darwin.
Mhm.
Darrow goes to the judge, he says, can I call an expert in the Bible? And the judge is perplexed and says, well, sure. And then he calls the prosecutor, William Jennings Bryan, a three-time presidential candidate. We've mentioned that. And deep religious fundamentalist, and he cross-examines him in the Bible. I mean, the whole thing
Could he
is
have
really
refused
worth reading.
to get to take the stand when he was called?
Why? What?
Could he have refused to take the stand at that
He
moment
could
when
have,
he was
but
told?
Brian had a tremendous ego. You know, he was
Yeah,
known as the great screecher, or the great. He was known as the great commoner, but he was also
yeah.
known as the great berserker. He loved the sound of his own.
So he was happy to take the pulpit. He thought he would be explaining to everyone else
Yes, and he was in front of his
what was at
people.
stake.
He was in front of his people. He was in the middle of the Bible Belt. They were all, but he didn't realize the whole thing was being recorded on radio, and the world was listening to this. I've said before in the previous podcast that Darrow destroyed him because he died 1 week after the trial, not in the film Inherit the Wind at the conclusion of the trial. But there's no doubt that the cross examination was. Uh, it's a bit like some of George Harman's cross examinations of the Tory MP. It was a destruction exercise.
Mm,
At the end of it, Bryant had nothing. Anyway, it goes some. You should read all of it, but here's a salient bit. He's asking about the Bible, and Brian says a witness had testified in Bishop Ussher's theory that the Earth was formed in 4004 BC. And
yeah.
Darrow says that estimate is printed in the Bible. And Brian says, in response, everybody knows, at least, I think most of the people know that was the estimate given. Darrow, but what do you think that the Bible itself says? Don't you know how it had arrived? Brian hesitates. Well, I never made a calculation. Darrow, a calculation from what? Brian, and this is a fatal response, I could not say. Darrow, from the generations of man? Brian, I would not want to say that. And then, Darrow, well, what do you think? Brian, I do not think about things about which I do not think. Darrow, do you think about things about which you do think? You've got him in a trap, yeah? Hello?
Hmm. Hmm.
You're an ignorant thought. I do not think about things which I do not think. Do you think about things about which you do think? Do you think about anything, in other
Mm.
words? And of course, there's also the closing speech, and it's full of Darrow's humanism and in the tremendous grasp of science and literature and history. The words ring through today. The famous peroration case. He says, if today you could take a thing like evolution and make it a crime to teach it in the public schools. Tomorrow, you can make it a crime to teach it in the private schools. And the next year, you can make it a crime to teach it in the hustings or in the church. At the next session, you can ban books and newspapers. Soon you may set Catholic against Protestant and Protestant against Protestant and try to foist your own religion upon the minds of men. If you can do one, you can do the other. Ignorance and fanaticism are ever busy and needs feeding.
Mm.
And that's the world today. It's not
Mm.
just a word of then. We are creating division. We are creating hatred. We're turning people against each other. We're not engaging in dialogue and censorship of literature or books. It becomes a slippery slope. And lawyers have been brilliant in many ways in opposing censorship and thought crimes and banning things. I mean, I think he's still alive. I think he's over 100 now, 102 maybe, or Jeremy Hutchinson, perhaps the last, if he is alive, with Sidney Kettridge, the last great advocate. Both of them are well over 100. I think Kettridge is 103. And of course, Jeremy Hutchinson was intimately involved in aspects of the Lady Chatterley's trial. Um,
Oh wow.
and of course, yeah, that really, and Kettridge, if Hutchinson is not alive, Kettridge, the great Doyle of human rights laws, still alive at 103, was Nelson Mandela's lawyer in Mandela's trial, and was
Mhm.
Steve Biko's lawyer, which is why he got booted out of South Africa.
Mhm.
And his Mandela speech, sorry, Kettridge's speech in favor of Mandela in his trial is incredible. But it would take a long time to read it out. But forensically, he dismantles the South African state. And so there's no doubt that advocacy, whether in terms of the cross-examination or art trade, can be a huge weapon or art form. Both the skill of cross-examination and the skill of the closing speech are intrinsic. Now,
Mhm.
we're talking about advocates and judges, but there's an odd asymmetry in all of this. Justice Jackson was a judge of the American Supreme Court, but he was seconded, Robert H. Jackson, as U.S. Chief Counsel to the Nuremberg War Crimes Tribunal, appointed by Harry Truman. And he became, therefore, the chief prosecutor in the War Crimes Tribunal. I think the stress of all of it shortened his life.
Hmm.
And his closing speech is brilliant, but he spent months drafting the opening speech, which had to redefine international law to define, in effect, crimes against humanity.
We're talking about a number of trials, right?
Yeah, but this is the trial. This is the main trial. This is the trial of Goering, and such was left at the high command.
Okay.
Bormann, I think, had disappeared, and Hess
Mhm.
had committed suicide. But there was
Yeah.
still some of the Nazi judges were there, and some of the architects of the final solution. Speer was there as well. Of course, he was the only one. Uh,
And he survived, right?
Hitler's well, yeah,
He
Hitler's
wasn't. Yeah.
architect. No, he wasn't executed.
Yeah.
And of course, he was very close to Hitler at the end. And
Yeah.
he's the man who was responsible for this new Germanic vision of a new Germanic city, the way
Yeah. New
Hitler's
Germania.
New Germania. And Speer was always, distant from the actual dirty work. But
Yeah.
nonetheless, I think a lot of people felt he got off far too lightly.
Yeah.
But he was living testimony, if of a hypocritical nature thereafter. But it's Jackson's opening speech that is incredible. He describes the defendants as relatively insignificant people, a bit like Hannah Arendt's comment about Eichmann and the Eichmann trial as the banality of evil. He says they're 20 odd broken men, their faith of little consequence to the world. It wasn't their identities that mattered. It was what they did and what they embodied. What makes this inquest significant is that these prisoners represent sinister influences that will lurk in the world long after their bodies have returned to dust. We will show them to be living symbols of racial hatreds, of terrorism and violence, of the arrogance and cruelty of power. They are symbols of fierce nationalisms and of militarism, of intrigue and war making, which have embroiled Europe generation after generation, crushing its manhood, destroying its homes, and impoverishing its lives. Um, Jackson was a very Christian man. Civilization can afford no compromise with the social forces which would gain renewed strength if we deal ambiguously or indecisively with the men in whom these forces now precariously survive. And on it went for 3 hours. It was absolutely
3 hours. That was his opening
devastating. Three
speech.
hours. 3 hours was his opening speech. Yeah. Absolutely extraordinary. Um, I mean, the longest speech I've ever given is about an hour, and you're exhausted at the end of that. Do you know what I mean?
Yeah.
You
Yeah.
really are. An hour and 10 minutes, maybe. But this went on in front of the world's cameras for 3 hours. And towards the end, he goes, civilization asked whether law so laggard as to be utterly helpless to deal with crimes of this magnitude by criminals of this order of importance. It doesn't expect that you can make war impossible. It does expect that your judicial action will put the force of international law, its precepts, its prohibitions, and most of all, its sanctions on the side of peace, so that men and women of goodwill in all countries may have learned to live by no man's leave underneath the law. Now, Jackson was a conservative individual, yeah?
Hmm.
And those words, of course, could apply to many of the destructive forces that are destroying and undermining the rule of law and international law today, and creating new forms of crimes against humanity or rethreading existing forms. And of course, the finger very much points to America. the current American administration in that way, doesn't it? But though not exclusively so. And we're entering a new age where there are crimes against humanity, the obvious ones of the Israeli genocide or what is happening in the Ukraine. But also, I think, the gradual destruction of human rights and entitlements and housing and healthcare, a kind of economicide that's been inflicted upon people by multinational corporations and neoliberalism, the triumph of mega rich greed. And it's noticeable in Jackson's speech. He refers to destroying its homes.
Hmm.
Well, of course, he was referring to people destroying, because he was a deeply conservative man. But of course, we're destroying in many respects, not least in Ireland, affordable housing, affordable structures of decent and reasonable living for people. The crimes against humanity concept goes on, and it's an incredible thing. Um, Jackson's speech, even though he was a prosecutor. Who I basically, I think I said in the last broadcast, I don't really like them very much. But he was less great as a judge, though he was a very good judge as well. But no
Hmm.
doubt the emotional effect of his involvement in all of that.
How long was
And
his closing speech? If his opening was 3 hours.
I don't know. I don't say anything. I think it wasn't too far from that.
Mm.
And, you know, I suppose to be patriotic, if we're talking about great advocates, I wrote an article in the Nigerian Lawyer, which was published after his death about 2 years ago. And I never did a case with him, although I did get to a case with Adrian Hardiman, who we mentioned perhaps in a different context, was Mr. Patrick McEntee. Mr. McEntee. And he's the most extraordinary man. Did you ever meet him?
No,
I know your uncle, I think. He's brief and regularly.
my
I remember,
family, yeah,
yeah.
my parents, he even lives quite close to my, family home
Well,
in Ranelagh, but I never met him.
flamboyance was not the word for it. I remember I was in a thing in the College Historical Society, and everyone's there. It's full of Mary Robinson's there, dressed very formal way. Everyone's there in a very formal his type gathering situation. And McEntee walks in, shirt hanging out, fags and a big not just fags. He had a holder for his cigarettes, and stubbing it all over the place.
Yeah, yeah.
Looking totally disheveled. And everyone runs around him, and he starts winding people up, and he was winding Mary Robinson up. And then, as he's winding her up, he was winking at me from the side of his eye. Now, the only time that has happened to me before was when I was in the presence of the very august Mr. George Carman, not particularly, according to his son, a nice man, but a brilliant barrister and a brilliant cross examiner. And Carman was winding someone up and winking at me at the side. So McEntee clearly had an impish sense of humor. I did see him in action, and I have read some of the things. I mean, like, there's the famous, you can't lie to the dead, the famous story that there was a bet in the law library that within, a couple of questions of his cross-examination, the entire court would erupt in peals of laughter, and he was cross-examining a, a farmer on the borders in an IRA case, because of course he
Yeah.
was famous for the representation of the IRA. Too much professional criticism. He starts up. He said, "He's a true farmer X that you've the finest pair of balls in all of Northern Ireland." Bulls, sorry. And he corrects himself immediately. And his representation of MacArthur and that plea bargain was extraordinary stuff. But
That's
I
Malcolm
think it's
MacArthur.
yeah, and but it's also wasn't he representing? It's also the extraordinary ability he had to pull acquittals from thin air and get people, judges even, to accept hugely improbable and fantastic propositions as fact. And if you read my article, which is in the Nigerian Law, you'll see that that there are examples of how he gets judges to agree about the possibility of somebody accidentally hitting their head, which is simply ludicrous. And I think he stands also as one of the great advocates. I don't
Hmm.
think there's been anyone quite as good as him since. And that's because that tradition of advocacy, of great cross examinations and colourful closing speeches, is intrinsically related to cases of public interest and colour.
Can I
And
ask you
that
a
means it
question
must,
about on this
yeah,
context about truth and beauty?
yeah,
It's an interesting question as to whether, say, for instance, dialogue, you can think to
yeah,
Shakespeare, or
yeah,
soliloquy, Shakespeare, or cross examination, or opening or closing speeches in the courtroom. Which one can convey more, the most kind of beauty, which is important, even if you're a lawyer, to captivate, and which one gets closer to the truth? I mean, the parts of Shakespeare that people often quote, maybe the most famous lines are actually often from soliloquies, and yet Shakespeare is mostly dialogue. And in the context of the courtroom and all of that, it's interesting to me that you do home in on these fascinating dialogue. That's maybe the more aggressive part, where you kind of go for witnesses and so on. But these closing speeches are really key too. I mean, you can sit through an entire trial, as I have done recently,
yeah.
at length for months, and then the composition of the closing speech can actually turn the entire thing around. In fact, the lawyer can set that up, as it were. They
Yes.
can establish things. They don't
A
actually necessarily
closing
eviscerate the witness, but the closing speech is what actually
speech is
casts the whole
a
thing.
A
It's a
closing speech
soliloquy.
is a soliloquy, yeah. Is read out, in effect, part of Darrow's soliloquy in the Scopes case. And Marshall Hall, of course, we mentioned earlier, closes his speech by saying God didn't give her a chance, why don't you? And it works. The danger of the elimination of the jury trial, which is a completely Stalinist um, initiative, particularly in Britain now, cutting it down or restricting it, which is a slippery slope,
Mm,
is that you get rid of the closing speech because a judge isn't affected by it. A closing speech is a work of art. Yes, it has to have a
mm,
factual matrix. You can't distort the evidence. But you're
yeah,
involved, as I say, in the interpretation business. You're telling a narrative, a story. I start off all my closing speeches by saying this is a story, and it's not necessarily a story for innocence, it's a story for doubt. Do you
right.
have a doubt? Why do you have a doubt? And then
Mm,
you can construct questions of prejudice or jumping to conclusions and
mm,
suggest that cognitive bias, it's an idea as old as Francis Bacon. We mentioned him in the last podcast that or Voltaire, we're all predisposed to believe that which we want to believe. We're all
mm,
capable of rushing to judgment. The reason you members of the jury are selected as a cross section of the community is to bring your different prejudices to bear and to detach yourself from them. If at all, don't get obsessed with the nationality of the defendant, their age, or the nature of the crimes. I mean, the problem in sex cases now has just become ludicrous. It's guilt by disinformation and guilt by accusation. Once social workers and police officers get an allegation, the whole Leviathan snowball of state hysteria gains pace. And then only when we're unpicking it later in a courtroom. I mean, I said in one closing speech, probably putting in a bit, but it worked. And I'm sure he was totally innocent. I won't mention his name, obviously. Very serious rape case. That not only should he not be in this courtroom, there should never have been a charge in the first place. And the whole thing was
mm.
disreputable.
I think to answer my own
People
question briefly,
underestimate the power of oratory. Yeah.
yeah, they do.
But
It is, and I suppose one reason it can resonate so much and why those Shakespearean soliloquies shine out for people is that really much of life, especially sadly the formative moments, are composed of a kind of looming sense of chaos and entropy, a breakdown in order, the possibility A of just continuing, but also B of like holding on to integrity. If you're in a terrible case with a terrible murder or a crime like rape or whatever, that the core of it really is a terrible moment, some kind of awful event. Um, but the greatest chance to kind of put order on life is through the medium of a kind of a gifted consciousness. In this case, someone who can weave things together with words. That's why they're there
Well, yeah, but also they're there to
to tell a story,
it's
to
very
put things
important.
together, to
Yeah,
order it in time. Yeah, yeah,
yeah,
yeah.
but you're dealing with a human being. You have to tell that
Yes,
person's story.
yes,
You've got to, as Darrow says famously, brilliant but very precise line, you've got to put yourself in the other guy's shoes.
yeah.
You've got
Simply
to
put.
understand the person. You upbraided Dr. Johnson correctly in the last broadcast for Johnson's advice of saying that lawyers should fake empathy. I agree that's disgraceful. And it shows how cynical Johnson was. Darrow was not cynical. He had an extended human sense of empathy and compassion.
Mm.
And I think Adrian Hardiman had that as well. And he saw everything from everybody's point of view. And that's why he was such a
Huh.
brilliant defense lawyer, because you've got to represent these child murderers, Leopold and Lowe, or these rich, preppy kids who killed another kid for kicks, or you've got to represent in all sorts of contexts. And Darrow had that ability of
Mhm.
empathy. His closing speech in some of his race cases, were the Scottsdale case, were also absolutely brilliant.
Mm.
I mean, any trial lawyer should be there's a collection of his writings, of all of his great addresses and closing speeches. And you can get it for a few quid, called Attorney for the Day. Not the biography, the collection of all of his speeches. And there's a wonderful introduction in it by William O. Douglas. And it was the advocate's gift of human transference, of putting yourself into somebody else's shoes, of
Mm.
understanding it from their point of view, has never been represented more brilliantly by any human being as an advocate than him. But that is the trick. That really is the trick.
Mm.
And it's not a trick, really. It is a story. And your obligation is to present this person's story, the story of their life, the story, as you kind of say, that led to the tragic moment. And all sorts of things can lead to a tragic moment. I mean, putting yourself in the other guy's shoes also involves an understanding. There, but for the grace of God, go I. Or one wrong turn, the Innocence Project, one wrong place, wrong time, a misjudgment. I've had tragic cases of dangerous driving, which are like that.
Mm.
Death by dangerous driving.
Mm.
And people often are in situations. And the tendency in this mobocracy of a society that we're creating worldwide is uh, to demonize people and accuse them of certain things, and denunciation by media, without understanding, even if somebody did do something, why.
Mhm.
And that, of course, leads to Darrow's famous plea in mitigation in Leopold and Lowe, the greatest plea in mitigation. We haven't even mentioned the plea in mitigation. In Leopold and Lowe, they had killed the boy. Darrow's obligation was to stop them getting the death sentence.
Can you
And he
introduce the
did
case
so.
briefly?
Sorry,
Leopold Lucius?
Leopold and Lowe were two very rich, preppy kids.
Uh-huh.
One of them was on his way to Harvard. They came from some of the best Northeastern American families. I think one of them had been accepted by the Harvard Law School. They were very established, and just for kicks, they decided to kill a slightly weaker boy. And they were both guilty of sin. The whole thing unraveled. And the
Terrible.
question was, should they? It was like the Jamie Bulger case of its time. It was shocking. And Darrow knew they were guilty. And his obligation in his famous peroration in Leopold and Lowe, which contains some of the most brilliant of his legal writing, was to convince the judge they shouldn't be executed. The whole thing is an extended treatise at one level. Darrow refers, a bit like Dostoevsky did, it's an interesting thing, isn't it, to barbarous laws of the past. Do you remember when part of Dostoevsky's motivation with his character of justice was seen when he was much younger, a landlord beat a serf to death. And Darrow
Mm.
refers to the way we had executed, point you were making on the last occasion, in historic terms. We had executed people for thieving and these horrible examples of putting people to death. And he goes right back to Stevens and the Victorian era and before. And so it's a work of history at that level, showing the barbarism of the death penalty. And then, of course, Darrow points out, which was intrinsic, because he was an intellectual, intrinsic to the way he thought. He was part of a movement of progressivism. I believe now somewhat quaint that society would get better, that everyone is a creature of their environment. They're all conditioned by their environment. It doesn't really matter if you like these people. They are they're determined, and of course, the finality of the death sentence would be to prohibit any form of rehabilitation. And the whole thing is magnificent. I think it also took 2 or 3 hours. They've actually got a book with it. I mean, a book published about it. It's collected in that book, Attorney for the Damned. But so I think the three ways advocate, and you're right about your soliloquy. The soliloquy comes in the closing speech of the plea and mitigation,
Mm-hmm.
the mercy plea.
Mm.
And Darrow's is the best example of the mercy plea because the stakes were so high, yeah, in Leopold and Lowe. Um, and the cross examination is more about deception, ruses, and I deliberately used Rufus Isaac's example of that surprise question in the Seddon murder case because it's an unfair question.
Mm-hmm.
Seddon was damned if he does and damned if he doesn't. Isn't that right? Now,
Mm-hmm.
Isaacs must have known he couldn't answer it properly. Similarly, in the other murder case, when Burkitt says, "What is the coefficient of brass?" there's no proper answer. So the consequence of that is it's a surprise question. It's brilliant. It's technically brilliant, but it doesn't have fully the sense of the truth about it. Yeah,
Mm-hmm.
unlike the closing speech, it's a technical, but it is of course a form of art or craft. Yeah.
Mm.
The other thing are judges or lawyers. I mean, can judges write literature? And of
Yeah.
course, unlike a lot of, and Rumpole talks about barristers' closing speeches being forgotten when they're dead. And you don't see in the law reports many examples of closing speeches. I mean, I've been reported many times in newspapers for things I've said, but, and they record my closing speeches now.
Yeah.
The point is, judgments are there. They are documents
Well,
through the
a trial
ages.
in Dublin with a female judge who was actually quite witty. It was quite a grim trial, but she spiced things up with little jokes at her own expense and things like this. It's quite surprising,
Did she
really.
get it right? If it's a trial I'm thinking about, I don't think she did. I- in terms of judgments as great literature, you
Yes.
might say you could even go back even to the legendary English judge Lord Mansfield
Mm.
on the question of slavery. I mean,
Yeah.
he's a good way to start. Some of his judgments are very interesting. 72. I just remind of this because I'm in Somerset at the moment, and it's called the
Oh, yeah.
Somerset case.
Right.
Yeah, it's called the Somerset case, but that's because the slave was named Somerset, and he releases him. He says the state of slavery is such a nature that it's incapable of being introduced on any reasons, moral or politically, but only by positive law, which preserves its force long after the reasons, occasion, and time itself from whence it was created is erased from memory. It is so odious that nothing can be suffered to support it but positive law. Whatever inconveniences therefore may follow from the decision, I cannot say this case is allowed or approved by the law of England, and therefore the black man must be discharged.
Mhm.
What he was saying is, you might have got your slave in a country without laws. We don't like it. It's not supported by our positive law, and I declare him a free man. And of course, you might say,
Mhm.
well, yeah, well, because views in slavery, but that strong Wilberforce abolitionist movement was there in Mansfield, and knocking around at around the same period, slightly later, was the architect of American constitutionalism, the famous first Chief Justice of America, Marshall, and judgments like Marbury v. Madison, which
Mm.
crisply outline the principles of separation of powers and the role of American governance, almost as well as Thomas Jefferson's Declaration of Independence, which is worth citing because Jefferson was such an Olympian intellect that
Hmm.
we should classify him as a lawyer as well. We hold these truths to be self-evident. All men are created equal, entitled to life, liberty, and the uniquely American value, pursuit of happiness.
Jefferson still lives.
Yes, those are John Adams. I mean, I think he says Thomas Jefferson lives, or John
Thomas
Adams'
Jefferson lived.
final, and of course he wrote the Declaration of Independence in 1776, with some, I think, contribution from John Adams. They were very much reconciled for the last 20 years of their lives, splendidly documented in David McCullough's 2001 book on John Adams. And but they're separated geographically and spatially.
Hmm.
Jefferson is in his fabulous pad in Monticello with all his inventions and creations, and Adams
Hmm.
is in a more different type of state. But they communicated, they made up, and it is remarkable that they both died
Hmm.
on the day of the 50th anniversary of the Declaration of Independence, which they were responsible for. Yeah, it's extraordinary,
Another
isn't it?
coincidence.
Well, yeah, it's absolutely extraordinary. And as you said, Adam's last words were wrong, but he thought Thomas Jefferson lives.
Hmm. There's something very
Um,
beautiful about it as well. It's like
well,
I think it's
they were
actually echoed
really
in a poem by John Berryman, who lived in Ireland, wrote beautiful, wonderful things called the Dream Songs. Anyway, there's just a moment in it where he says Thomas Jefferson still lives. I read that line of his and I didn't know what it meant, didn't know what it referred to. I thought he was just saying that his spirit was still alive. But of course, that's what Berryman is trying to capture, this sense that that
well, it's also
utterance
what
has a kind of timelessness.
John F. Kennedy was trying to capture, I think. Kennedy famously had a meeting, a dinner in the White House with all these Nobelists, and he cites Stanley says, "There's more intelligence in this room than any time in the White House's history, except when Thomas Jefferson dined alone." I mean, Jefferson was a total polymath, you know? I mean,
Yeah.
he wasn't a great president, but he's a constitutionalist, he's a deist, he has a
Mm.
very strong understanding of religion. He was an architect, which is what Monticello, his famous place, is about. He was an inventor. He was a creature of relentless intellectual curiosity.
Mm.
And but of course, he was also a slaveholder,
Yes.
and that is a point of huge criticism of him,
Did he
and a
father
point of real
children with
disagreement.
any of his slaves?
He did. Sally Hemings, I think. And funny enough, I think Nick Nolte, of all people, plays him in a film called Jefferson in Paris because he was ambassador to Paris also at a very fraught period of time.
Yeah, really exciting that.
Yeah, no, a very fraught period of time, just as the
Yeah.
revolution was getting worse and worse. But I think we
Yes.
should classify Jefferson as a lawyer. But
Mhm.
if you talk about American lawyers, we mentioned Chief Justice Marshall. All roads lead to Oliver Wendell Holmes, and
Yeah.
as a judge, as a legal writer, Holmes was one of the most titanic intellectual figures, not just lawyer of the 20th century. He was a war hero, a jurist of enormous distinction. He was on the Supreme Court in his 92nd year.
Yeah.
He was only appointed, I think, just about 60. They thought he wouldn't live very long. Boy, were they wrong. And his judgments display, and he is, more so than Clarence Darrow, one of the founders of this philosophical movement called progressivism, splendidly documented recently in a book called The Metaphysical Club. And there's a whole intellectual basis going through all of Holmes's judgment. The first, of course, is his hatred of the unregulated free market and the treatment of
Okay.
the ordinary Joe in that context.
Okay.
And in that sense, the progressive wanted progressive wages, better health conditions for workers, less exploitation. And Holmes was tremendous in that way. And that leads to the most famous, shortest dissent. But the dissent has become the governing case. When there was a New York statute about regulating bakers'
Mhm.
conditions of works and hours, And the
Mm,
majority of the Supreme Court were totally pro freedom of contract and
mm,
laissez faire and said government couldn't intervene in improving workers' health conditions. And
mm,
Holmes dissented. The entire judgment can be read out. It's very short. Basically, the salient bits are this case is decided upon economic theory, which a large part of the country does not entertain. If it were a question whether I agreed with that theory, I should desire to study it further and long before making up my mind. But I do not conceive that to be my duty, because I strongly believe that my agreement or disagreement has nothing to do with the right of the majority to embody their opinions in law. A constitution is not intended to embody a particular economic theory, whether of paternalism in the organic relation of citizens, state, or of laissez-faire. It is made for people of fundamentally differing views. The liberty of the citizen to do as he likes, as long as he does not interfere with the liberty of others to do the same, which has
mhm.
been a shibboleth for some well known writers, is interfered with by school laws, by the post office, by every state or municipal institution which takes his money for purposes thought desirable, whether he likes it or not. The 14th Amendment, that's the Liberty of Contract Amendment, does not enact Mr. Herbert Spencer's social static. And Herbert Spencer was a British sociologist who coined the term survival of the fittest.
Hmm.
That is attributed as one of the founding stones of social Darwinism. What Holmes is saying is, a condemnation of mode of regulation of society, which was brutal and vicious and contrary to the interests of working class people. And the progressive legislation to improve and ameliorate the lot of working class people was being struck down by a Supreme Court subscribing to laissez-faire and survival of the fittest. But of course, history kind of repeats itself in different ways. That's where we are now, certainly in Ireland at given
Mm.
levels. I mean, I really do think that I'm sure they don't read very much, but perhaps Micheál Martin, as he confronts the housing and homelessness problem of Ireland, he would do well to read a book published pretty much very close to when Lochner came out. Lochner's judgment was 1903. I think this book was published in 1905 by the legendary progressive and socialist. Whether Holmes was a socialist, I'm not sure. Upton Sinclair, called The Jungle, set
Yeah.
in the Chicago meatpacking industry. And there is no question that intelligent opinion of that time saw the dangers of the unregulated free market. And of course, one of Holmes' colleagues at the Supreme Court, the legendary Harvard lawyer Louis Brandeis, saw the dangers of an all-powerful state. And the whole of Brandeis's career is against the intrusion of privacy by the state, by private entities, but primarily by the state. Those people were true progressives. And now we have a situation of unregulated intrusions of privacy, not least by our surveillance state, the retention of unlimited and unchecked
Sadly so, yeah. It's surveillance
of EU law.
capitalism, which is many of our leading FDI companies whose business model is
But
based on
also it's
surveillance
Helen
capitalism,
McEntee going into
and
an
then you have a
in-camera
surveillance state.
procedure and having data retention for some perceived non-existent threat of everybody. And no one knows the reasons adduced or why. And TJ McIntyre at the UCD Law School said, well, therefore you've rendered EU law meaningless. And there's no doubt the whole spirit of those people, the great Louis Brandeis and his defense of liberty speech as well, and
Mm.
um, um, you know, clear and present danger is only the justification for one level, the negation of speech rights, liberty and privacy, as well as their social concern. And they were going to kind of set up generations. Holmes was the inspiration figure, but we have people like Brandeis as well, and even
Mhm.
Frankfurter later. And it culminates with, someone like William O. Douglas, who was appointed by Franklin Delano Roosevelt in his early 30s as Supreme Court judge. But lest you think I've taken all the Kool-Aid on the liberal progressives, there was a downside to them as well. And the downside with Holmes was pretty chilling. Liberals or progressivism can also lead you down very dangerous paths. And it seems to me that his awful judgment in Buck v. Bell is the way many socialist progressives even think today.
Can you
And it's
introduce?
just, well, yeah, it's Carrie Buck I'm going to choose my words not in the way that Holmes chose them. I think he said she is the probable potential parent of socially inadequate offspring. And that's what he said. And the question was, should she be compulsorily sexually sterilized
Okay.
under the due process law? And
Hmm.
Virginia had agreed to do so. And this is, a massive intrusion on someone's liberty and
Hmm.
somebody's privacy to compulsorily sterilize them. And there's always been that really nasty tendency within Fabian socialism of an overweening, all-powerful, we know what's good for you. The nanny state, in fairness to Thatcher, she attacked it, yeah?
Yeah,
And
some people
that is,
see the drift towards euthanasia in many
well,
Western democracies as
I think
being
that's
an example
part
of.
of I think it really is, because you've got to be very careful about safeguards. And I wrote something in Council magazine about that bill in Britain. And I said, it's better that safeguards are interpreted by judges, not by committees, or not by other people, not just as the American Supreme Court worried about in Washington v. Glucksberg about the integrity of the medical profession. But in a world of diminished and diminishing resources, I'm almost quoting myself here, this whole impetus towards euthanasia is extremely dangerous. That is not to say it is not justified in certain circumstances and the deprivation of that choice, but it is the pressures put on people to exercise that choice in a world of perilous resources and limited support that is a form of dehumanization.
Yeah, it will
And
happen. And also the governments are specializing more and more in what they call nudge psychology, whereby they don't order you to do something, but they use
oh, well, that's
what
the
resources
subtle
they have to
mechanisms of
continuously
control.
suggest it to you,
Yes, exactly.
suggest that you take a course
I
of
almost
action.
feel
Yeah,
like, yes, exactly. I almost feel like when I'm looking at some of the billboards around London, I should
that's
have
right.
glasses that are stop me from looking at them, because it's obviously it's so we're living in a world where the blatant and the obvious is winning because nobody's giving out stink about it. But if we go back, I think the euthanasia analogy is completely correct to Holmes's judgment.
Hmm.
Now, prepare yourself for the shock of this, right? In view of the general declarations of the legislature and the specific findings of the court, obviously we cannot say as matter of law that the grounds do not exist. If they exist, they justify the result. We have seen more than once that the public welfare may call upon the best citizens for their lives. He was writing shortly after the First World War. 1920s. It would be strange if it could not call upon those who already sap the strength of the state for these lesser sacrifices, often not felt to be such by those concerned, in order to prevent us or being swamped with incompetence. It is better for all the world if instead of waiting to execute degenerate offspring for crime or to let them starve for their imbecility, society can prevent those who are manifestly unfit from continuing their kind. The
Hmm.
principle that sustains compulsory vaccination is broad enough to cover cutting the fallopian tubes. 3 generations of imbeciles are enough.
Hmm.
I mean, it's shocking. And this was from a great progressive
And of course,
and
there
a
would have
great.
been results from that. I mean, that really must have resulted in thousands of or tens of
Well,
thousands of
well,
civilizations.
exactly. There is a strong objection, particularly in this day and age, to giving the Leviathan, the state, too much power. Certainly, Hardiman spent most of his career objecting, sometimes rightly, sometimes wrongly, to the intrusions of the nanny state and the Irish state, because we don't
Adrian
want
Hardiman.
governance. Yes, we don't want governance by social workers or police officers because they're usually shockingly stupid and always, almost always wrong. Hardiman's great, I'll speak of him, I suppose, his great contribution to, and I knew him, obviously, and had a huge respect for him. He's the last great Irish judge. None of the rest of them are fit to lick his boots, and never were, really. I don't think any of them, and that includes some of them in the Supreme Court, were fit to lick his boots as an advocate. Never mind. And the reason is he was like Holmes, he had I think Jared Hogan said to me, he had a Holmesian intellect. And he certainly did. He had a massive, wide ranging mind, more comfortable discussing history or literature. I mean, he wrote
Hmm.
this famous book on Joyce and the law, but I mean, I once, over pints, as a gambit, he sat down, he recited the collective works of Shakespeare off the top of his head. Yeah. After about and he could talk about to almost anybody about almost anything. He was very, very interested in the Innocence Project and miscarriage of justice. I had lovely evenings with him about that. And he was towards the end of his life very good to me. Now he had his faults as a human being, but and he would more be as likely to talk to a docker as he would be to a judge. And I think he had a legitimate intellectual contempt for his
Oh.
colleagues, and he was right. And that basically, because we've bred a generation of technocrats and they're bloody useless. And that comes out in the JC case, his great contribution to our laws in all sorts of ways, where he was outvoted. And I think it broke his heart. And over a number of
So
years
what was the
previous,
JC case?
the JC case is the ultimate, there have been subsequent ones like Quirk, but it's the case which destroys carefully wrought precedent over a number of years on the control of the Irish police. And it comes to the conclusion the majority of the court, all commercial lawyers, way out of their depth. Whatever one thinks about Donald O'Donnell, he's always out of his depth and too statist in criminal justice terms. And I don't mind saying that. And his judgment and that of Clark are useless. Hardiman got it right, as ever. And what he's saying in the judgment is that it's a basic thing at one level. You're saying that you can't exclude police evidence if the mistake they make is inadvertent. And Hardiman's simple point, I mean, the judgment is tremendously, we'll go through most of it, but his simple point is, well, they quote Mandy Rice Davis, they would say that, wouldn't they? The cops will say something is inadvertent, where it was a deliberate, conscious violation of your rights. You're giving them a get out.
Can you just remind what was actually at stake? Who was JC?
Well, I think is it anonymized or for the purposes of I don't even if it isn't, I don't necessarily want to. What's at stake is due process. What the JC case is about the elimination of due process in Ireland in criminal
Okay.
justice terms. And what it means is there was a thing called the exclusionary rule that was developed in the 70s and 80s, particularly Judge Finlay in the Supreme Court, which is that if the cops engage, they can't mask over an illegal act, an unconstitutional act in their behalf,
Sure.
and you can't admit what are called the fruit of the poison tree, that any evidence acquired as a result of police illegality should be excluded. That could be real or testimonial evidence. That could be a confession coerced, induced, and their tactics of nonsense. Or it could be evidence they claim to have found as a result of an illegal search and seizure. So, in effect, the Supreme Court, ultimately, after various High Court decisions, get rid of this crucial component of due process and allow for the admission of unconstitutionally obtained evidence by the police saying we made a mistake in good faith. And of course, they would say that, wouldn't they? And that's Hardiman's
Hmm.
point. And I think I may have mentioned that I was with it when they came up. One cop came up to me and said, "No, it'll all be a mistake from now on, Adrian." Oh yeah, and I think it drove him mad how stupid his colleagues were. Well, I think he felt they were just uncultured. But the other point is, and uncivilized. But the other point is
Hmm.
that the the language of the judgment is so extraordinary. The level of erudition he compresses. He quotes Holmes. He quotes Lord Atkin. We haven't even mentioned his legendary judgment in Liversidge v. Anderson, and Atkin was of Irish extraction. And in seeking to strike down a Home Secretary's opinion in the nineties as to whether somebody was an alien or not, He called it Alice in Wonderland or Humpty Dumpty logic. That's what Lord Atkin said, because the
Mm.
minister determined whatever he wanted. Words are whatever I mean them to be. And that was Hardiman's focus of his attack on the majority, on his colleagues' opinion. And he accuses his colleagues, in no uncertain terms, of outright stupidity. And he accuses them of making arguments about the possibility of a trial which make no linguistic or syntactical sense and are simply not just wrong, but put in bad faith the arguments to get rid of the exclusionary rule. And he's very critical of some advocates who appeared before him who are now Supreme Court judge in advancing these arguments. And he also points out the distinction between state power and the individual, the double standards involved. And that's his Humpty Dumpty logic, Hardiman's in the JC case, which is that the state wants its cake and eat it. They want it their own way entirely. They are condoning mistakes they make, but if the ordinary person makes a mistake, they're crucifying them. And at
Yes.
points, he was a great wordsmith, Hardiman, at all sorts of levels. If you've heard this phrase called ordre public means public order. It's almost a limitation rights. But Hardiman sort of bends and twists it, and he calls it force publique. He uses the phrase force
Uh,
publique for the police and
bit like
the
force
state.
majeure and things.
Yes, we're creating a
Mm.
police state. And he says, not only in the council, I think that Brian Murray was one of them, advancing the arguments, they should feel ashamed for advancing
Mm. Mm.
that the state should feel ashamed of this case.
Mm.
Now, that's kind of Hardiman's naming and shaming them. And the
Mm.
subtext of all of it is he realized that there is a collusion between the state authorities in Ireland and the police, the
Mm.
Justice Department, and it does not favour the interests of the individual. And that those lawyers who succeed by virtue of their adherence to the state, which Hardiman never
Mm.
did, really don't. They're increasingly authoritarian. They're increasingly anti the little guy. And certainly that's true in this case. And they are increasingly inclined to manipulate language in ways it can't be
Mm.
manipulated that make no sense.
In that context, interesting to think judiciary
Well, it makes the
and
present
state.
Irish judiciary, yes, and state adopts a statist, authoritarian, renegade position on everything. I choose the word renegade advisedly because if you look at subsequent cases to the JC case, the Quirk case, for example, they now ignore if there's an EU data regulation of privacy, they ignore EU law or ECHR law. We are
Huh.
only nominally internationally applied state.
It's interesting to think in that context what judicial oversight means here and who and when
Yeah.
are judges accountable.
Yeah, the Brits take the convention seriously, even though they talk about leaving it. And Starmer does now. The Irish
Mm.
judges don't. If they disagree with it, they say, we've got our own constitution, we're not following it. And now they've reached the point,
Right.
this is real delegitimacy. They shouldn't really be legitimately recognised, where they sidestep EU law. Hardiman saw it coming in
Um.
his special matrix of the criminal
Yeah.
justice system. And it is a great tragedy that he died so young. Um,
Yeah.
I mean, obviously, you know, because he was like in terms of criminal justice, he was a bulwark of civil liberties. He was also infinitely more educated than the rest of them. I mean, the judgment is just the amount of literary references, not just Adkin and Holmes, the way he adopts a kind of legal realist position where he says, if you're trying to introduce this, here's what's happened. And then I think it's part 5 of his opinion. He goes through the litany of Garda atrocities. But the word ashamed it's like alliteration in literary technique. The word ashamed comes through it all of the time. He's
Right.
suggesting they should be prosecutors ashamed for making these arguments.
Hmm.
They actually tried to get the earlier judge in a catch-22 situation. Hardiman quotes Joseph Heather's novel in that respect. They're saying she shouldn't have applied the Constitution as was, but she was obliged to do so, and now you should negate the Constitution and order a retrial when all she was doing was applying the Constitution in the first place. And there is the
Right.
public are duped by this. And very few people within the legal profession speak out. But let's be crystal clear about this. There has not been a judge of Adrian Hardiman's education, ability, and courage since. And it's scarcely evident.
I think it's also pertinent to point out this kind of integrity that he has, given that the special criminal court is about to be fired up again.
They want non-jury courts to create fake emergencies, which was the data thing, fake allegations. They'll extend, yeah. I mean, one of my arguments against the offence bill, as in, initially drafted, and I read quite a lot about it, and I think I lobbied with certain political parties, and I think it had an effect, was that, at this stage, when we're going to reach a point that if you offend them, they'll try and put you on trial before a special criminal court of a judge they select. We have turned
That's
into
right.
a police state. If,
And if they offend you,
if they offend you by falsely accusing you and locking you up, tough, yeah. It's
that's it.
shockingly one-sided. And the point is, within the narrow confines of the people who profit in promotion in judicial terms of the state in Ireland, they see nothing wrong with this. And then they try and mask over their outright perverse criminality of some of their decisions internationally. I mean, that's the bizarre thing about it. And,
Hmm.
the special criminal court back in, due process completely destroyed and obliterated, state surveillance coming in the door, and
Yes.
recent murder trials, which have been show trials.
Do you think that there might be in Ireland something like an equivalent of a star chamber?
I think so. Yeah, I think there are people who
Possibly.
whispering galleries between the pot. I mean, the country's too small. Even Sutherland said it's ungovernable or never really worked. I mean, and that's because there's whispering galleries between the prominent families, the politicians. They're all interrelated or
Hmm.
intermarried, and the Justice Department and so on. But I mean, in a
Hmm.
way, one doesn't necessarily mind a star chamber if it reaches the right conclusions, but not if it's got.
Hmm.
Hardiman was a man of integrity. I mean, it's very rare. Isn't it very odd to say of someone he's a person of integrity? You'd expect a judge to be,
Hmm.
but he did have integrity. And of course, his career was as a criminal defense lawyer, and and I mean, he was a patriot, but I don't think he had much faith in the Irish state. Sure, he knew them too well. And it's always a
David,
problem when Fine Gael have too much power. Yeah.
I think that's enough for today.
Uh, I think that can I just mention Lord Denny? Can we have we time for that?
Okay, briefly.
Okay. Now we've spent a lot on Hardiman, but the greatest prose master of them all is Lord Denny, and and just he writes beautifully. I mean, his judgments are literature. The Master of the Rose in Britain, they really are. And you can select any number of them. And the most extraordinary thing about Denning's judgments is by the time you've read the first paragraph of the judgment, you know what the conclusion is going to be. So, briefly, in Miller v. Jackson, this couple buy a house in Linson, County Durham, and it's beside the local cricket ground, and they want to shut it down. And they say it's a nuisance because the cricket balls are coming into the back garden. Look, hello?
Okay, yeah.
Okay. Here's Denning's opening paragraph, Miller v. Jackson, 1977. You got to read this. In summertime, I'll impersonate his accent. In summertime, village cricket is the delight of everyone. Nearly every village has its own cricket field where the young men play and the old men watch. In the village of Linson, County Durham, they have their own ground where they have played these last 70 years. They tend it well. The wicket area is well rolled and mown. The outfield is kept short. It is a good clubhouse for the players and seats for the onlookers. The village team play there on Saturdays and Sundays. They belong to a league competing with the neighbouring village. On other evenings after work, they practice while the light lasts. Yet now, after these 70 years, A judge of the High Court has ordered that they must not play there anymore. He has issued an injunction to stop them. He has done this at the instance of a newcomer who is no lover of cricket. The newcomer has built, or has had built for him, a house on the edge of the cricket ground, which 4 years ago was a field where cattle grazed. The animals did not mind the cricket. How does he know that? Is he anthropomorphic? But now this adjoining field has been turned into a housing estate. The newcomer, four-time mentioned, alliterative repetition, bought one of the houses on the edge of the cricket ground. No doubt the open space was a selling point. Now he complains that when a batsman hits a six, the ball has been known to land in his garden on or near his house. His wife has got so upset about it, they always go out on weekends. They do not go into the garden when the cricket is being played. They say that this is intolerable. So they asked the judge to stop the cricket being played. And the judge, much against his will, has felt that he must order the cricket to be stopped. With the consequence, I suppose, that the Linz Cricket Club will disappear. The cricket factory will return to some other use. I expect for more houses or a factory. The young men will turn to other things instead of cricket. The whole village will be much the poorer. And this because of a newcomer who has just bought a house there next to the cricket ground.
And
Yeah.
what was the conclusion of the case?
Well, he was wrong. There's a part in the judgment which gets to the law. And he goes, that was the law of the 19th century. This is the law of now. So he was just deciding against them. But what he did do was he wouldn't grant the injunction and he wouldn't give them damages. And there are parts of the judgment where he effectively refers to the wife as neurotic. But he persuaded his other judges only to award damages.
Mm,
And even though I think he was technically wrong, Denning had, which is a good thing, no respect for priesthood if it was wrong, you know. And
right,
he really did. I mean, and he would of course create priests. Famously, the High Trees case, his creation of the doctrine of promissory estoppel, was going back to an ancient case of the 17th century in Lincoln's Inn Library and digging it up to create new doctrine. And in Miller v. Jackson he goes at all the authorities against him, which are about coming to a nuisance. The fact that they bought the house that was a nuisance doesn't matter. He goes, that was the law of then. This is the law of now. And then he just changes the goalpost completely. And so he's
right.
technically wrong, but morally he's correct. And in community driven terms, he's correct.
It's
This
pretty great to talk about precedent in that way, especially to do with a cricket game, something that goes on for so long.
represented something intrinsically good about Britain at many
Yeah.
points. He had a sense of great community about him. I was also very innovative in matrimonial matters and women's matters and constructive trusts, and his sympathies were always with the little person. More, right? This is about the little person. Lloyd's Bank v. Bundy. Shortly afterwards, think about 78. Brudchalk is one of the most pleasing villages in England. Old Herbert Bundy was a farmer there. His house was at Yew Tree Farm. It went back for 300 years. His family had been there for generations. It was his only asset, but he did a very foolish thing. He mortgaged it to the bank up to the very hilt, not to borrow money for himself, but for the sake of his son. Now the bank has come down on him. They have foreclosed. They want to get him out of Yew Tree Farm and to sell it. They have brought this action against him for possession. Going out means ruin for him. He was granted legal aid. His lawyers put in defense. They said that when he executed to charge the bank, he didn't know what he was doing, or at any rate, not the circumstance was such that he ought not to be bound by it. At the trial, his plight was plain. The judge was sorry for him. He said he was a poor old gentleman. He was so obviously incapacitated, the judge admitted his proof and evidence. He had a heart attack in the witness box, yet the judge felt he could do nothing for him. There is nothing, he says, which takes this out of the vast range of commercial transactions. He ordered Herbert Bundy to give up possession of Yew Tree Farm to the bank. That's the opening paragraph. What do you think Denning does?
Hmm.
And, or commercial judges, those decided such cases, the Danske Bank case or any other cases on contractual misrepresentations, distortions by our banks. I think goes even deeper. It goes to questions of NAMA and for offshore accounts and everything. Should look at that judgment and read it.
Did he keep the? Did he keep?
Of course he did, yeah. And,
Mhm.
technically, Denning might have been wrong. His other judge in the case seems to suggest only on these exceptional facts. But of course, it doesn't really matter because if the law is an ass, I'm Lord Denning, and he's right.
Yes.
And
Yes.
that's what we should have been doing in the housing cases all the way through and
Right.
the repossessions, because the law has been created to be an ass in favor of banks leaving the country, vulture funds, and the horrific
Destroying people's homes.
destroying people's homes on fraudulent promises, misrepresentations, reneging on things they said in the first place, exiting the country, whereas billions disappeared at the time of the guarantee into Cayman Island bank accounts, and making
Mm.
freehold and leasehold ownership an impossibility for everybody else. I think that the thread that unites Hardiman and Denning together. Now, they had their fault lines, both of them. Hardiman was bad on issues to do with sexual discrimination and issues to do with states subventing people suffering from disabilities. He's anti-statism, bounds. And Denning, of course, was occasionally had a blinkered view of sort of, I'd say Irish issues, whatever. But both were
Yeah.
effectively in favor of the little guy. Yeah. And
Mm.
the little person. And they were against authorities that tried to crush the little person. And that means
And that is rarer
violence.
nowadays.
Well,
Yeah.
yeah, I think that's the point. I think it's very difficult
Mm.
to get someone who's anti-corporate or the word is not anti-state, that is holding the state to account. But if you don't have people like that, you don't have the rule of law in a polity or a society. And
David, thank you very much. That's enough for today, and we'll carry on in the next episode, perhaps stirring
I think
closer to the
that's enough.
present.
I think
Yeah.
I think that's enough for lawyers as literature. But within the structure, just briefly, you said within the cross examination, a plea and mitigation, a closing speech, or occasionally judicial judgment. Certainly in Lord Danning's case, law can be literature.
Absolutely. Absolutely.
Okay, take care.
David, thank you very much.
Not all back.